Hello and welcome to this edition of Creating Open Works. This video will cover the Creative Commons licenses, the license types, components, structures, designs, limitations, exceptions, and the two public domain options that are provided to us through the Creative Commons nonprofit work and body of Creative Commons licenses. To begin, we will look at the makeup of an individual Creative Commons license. There are three components to the makeup of an individual Creative Commons license. The first being the legal code. The legal code is the base layer. This contains the lawyer-readable terms and conditions that are legally enforceable in court. The second layer is the common deeds. Those are most well-known layers of the licenses. These are the web pages that lay out the key license terms in so-called human-readable terms. The deeds are not legally enforceable, but instead summarize the legal code. Some examples being the CC BY NC, and other types of forms and how they differ. And the final layer of the license design recognizes the software plays a critical role in the creation, copying, discovery, and distribution of works. This final layer is referred to as the machine-readable version of the license. When the metadata is attached to a CC licensed work, someone searching for a CC licensed work using a search engine like Google or creativecommons.org or any other advanced search tools, these machine readable levels are what informs those search engines and helps them identify certain license types and works. So now that we have a base understanding for the makeup of an individual Creative Commons license and the structure of it, let's talk about the varying levels of copyright licenses provided through the original traditional copyright and the Creative Commons, and then the additional layer of the public domain and the additional openness that works covered under those two licenses provides. So this image is a wonderful little image to take a look at. Imagine to the right, that is the traditional copyright as the most restrictive. Then we have the Creative Commons licenses, which we'll cover in a moment in depth. In the middle with some rights reserved, and that's very much a spectrum. And then finally on the left, we have our two public domain license types, or at least acknowledgments of public domain, and then no known copyright. So a little bit of a subtle difference there, and we'll get into that in a little bit. So before we jump into the different license elements and their meanings, I want to briefly talk about how these Creative Commons licenses are copyright licenses. And we need to unpack this a little bit in two certain ways. Creative Commons licenses operate or apply when the work is within the scope of copyright law, and the restrictions of copyright law apply to the intended use of the work. And second, certain other rights, such as patents, trademarks, privacy, and public rights are not covered by the licenses and must be managed separately. This is a key limitation and exception of Creative Commons licenses. Creative Commons licenses are appropriate for creators who want to provide people with one or more of the permissions governed by copyright. And that gets back to when I was talking about the spectrum of Creative Commons licenses and how we apply them for our own use and end users' use. But one good exception to this is that Creative Commons licenses do not give someone. One good exception of this is Creative Commons licenses give someone permission to read your article or watch your video, because reading and watching aren't activities that copyright generally regulates. This is another limitation or exception to Creative Commons licenses. There are two additional exceptions I'd like to quickly cover before getting into this, one being when you are using a work under fair use, fair dealing, or some other applicable limitation or exception to copyright. By design, CC licenses do not reduce, limit, or restrict any rights under those exceptions and limitations. And when the work is in the public domain, CC licenses should not be applied to works in the worldwide public domain. All CC licenses are clear that they do not have the effect of placing restrictions on materials that would otherwise be unrestricted. These are two key exceptions to keep in mind as you plan to license your own open and creative work. So, getting back to the topic at hand, the different license elements and their meanings. Now that we know those exceptions and we know that there's a spectrum, let's look at the individual components or elements of a license. The very first top one being the little human-looking image or symbol on the left, and this simply means attribution by. If you see the little human associated with the by or by, all licenses include this condition, except for the public domain. The second one, with the money sign with a cross through it, means non-commercial or NC use. You will see the NC in the code, the quick symbol code for a license, and you will know that it's non-commercial use, which means the work is only available to be used for non-commercial purposes. 3 of the CC licenses include this restriction, but not all of them. The next one, we see the rewind symbol. This symbol means share alike, or as you will see, SA, which means the new adaptation based on this work must be licensed under the same license. 2 of the CC licenses include this condition. And finally, the equal symbol in the final symbol on the bottom. This symbol means no derivatives, which means reusers cannot share adaptations of the work. 2 of the CC licenses include this restriction. They can share the same work, but they cannot create a new version of it, and they cannot share new derivatives of it. So these 4 symbols in different equations or different formulas give us the next step of all of the spectrum of Creative Commons licenses, which can be seen here. And on this page, the very top is probably the least restrictive, and at the very bottom, that is the most restrictive license type. But these are the 6 Creative Commons licenses, not including the public domain licenses or images that Creative Commons has created to identify those items or works. So these ones are the spectrum of copyright restrictions that we can apply to our work, and also let our end users or reusers know what they can and cannot do with our work. The very top being CC BY, so we're just giving attribution to. The second one being CC BY SA, which is we're giving attribution, and the end user has to share alike and use that same license type on their resulting derivative. The next one is CC BY NC, which we know is give attribution by, and non-commercial NC, and this allows people to use the work for non-commercial purposes only, and only as so long as they give attribution to the creator. The following one, CC BY NC share alike, is attribution, non-commercial, share alike. This allows people to use the work for non-commercial purposes only, as long as they give you the creator attribution, and makes any adaptations they share with others available under the same or a compatible license. So they have to use that same license or a compatible license. The next one, CC BY ND, which is attribution and no derivatives. So allows people to use the unadapted work for any purpose, even commercially, as long as they give attribution to the creator. They cannot make derivatives and they cannot adapt the work. And then finally, CC BY NC ND, attribution, non-commercial, no derivative. This is the most restrictive license offered. It allows people to use the unadapted work for non-commercial purposes only, and only as long as they give attribution to the licensor. So this is a very locked down license where you cannot make new adaptations or new versions or new derivatives, and you cannot use it for commercial use, and you have to give attribution to the licensor or the creator. So that covers the spectrum of Creative Commons licenses. So now let's dive into the 2 remaining licenses that are discussed by Creative Commons and seen throughout the world. And those are the public domain marks. And there are actually 2 of them. You'll see on the left a circle with a 0 through it and public domain, and then you'll see one with a C and a cross through it with public domain written into it. So the very first one, CC0, you waive, by using this license, you as the creator waive all copyright and related rights together with all associated claims and causes of action with respect to that work to the extent possible under the law, under the copyright law. When CC0 is applied to a work, copyright and related rights are relinquished worldwide, making the work free from those restrictions to the greatest extent possible. This is the most open, most free to use license type or copyright aspect. The final one, the second one, the public domain mark is used to label works that are already free of known copyright restrictions. Unlike CC0, this one doesn't change the copyright status of a work. This is simply a marking of an unknown or free of any known copyright restrictions. PDM can be used by anyone and is intended for use with works that are already free of known copyright restrictions throughout the world. So very much an indicator of an item or an original work being free of known copyright restrictions. These are the 2 public domain marks offered to us by Creative Commons. I hope this video was helpful in providing some insight into the types, structures, and uses and limitations and exceptions of Creative Commons licenses in relation to the varying levels of copyright law and the rights provided underneath those varying degrees and license types. Thank you so much.